Attorneys, which, WTF, case nuked your brain so hard you questioned if reality just rebooted. Story 1. Hi, smart legal people. A few years prior, my client became a partial owner in an online business started by a friend. The business is structured as a multi-member LLC, taxed like a partnership, in Oregon. My client and one other partner each hold 20% equity, while the founder holds the remaining 60%. For a number of reasons, my client needs to exit the business and move on with their life. Unfortunately, there is no operating agreement in place. While my client made extensive efforts over time to secure signatures on one, it never materialized. Roughly 2 weeks ago, my client gave formal notice of their intent to exit to both partners. The minor partner accepted the notice, and they've been collaborating on a transition plan. The major partner, however, has not responded to any form of communication. It appears he is frustrated and not yet ready to engage. All communications have been via email due to frequent travel and remote operation of the business. Despite the personal relationship and a shared desire for the business's continued success, my client intends to structure their departure fairly and responsibly for all parties involved. Their question: what should they be doing now to protect their interests and execute this exit correctly, especially given the unresponsive partner? Is email with read receipts sufficient? Should they escalate to certified mail or another method? What timeline should they be following? My client has numerous additional questions, but is focusing on taking it one step at a time for now. Based on my own research and theirs, Oregon law appears to allow LLC members to withdraw from a business 6 months after providing notice while still retaining an economic interest if no buyout agreement is reached. My client has invested considerable effort in building this moderately successful business, generating over $100K annually. They're committed to protecting their economic rights while exiting with integrity. There are countless ways this situation could evolve, but the immediate concern is identifying the right next steps. Thanks in advance. P.S. We anticipate this being a lengthy process and plan to share updates here as things unfold. Update. First, a quick update. My client initially retained a non-litigation business attorney to determine their ownership rights. While helpful, that approach stalled. After months of silence, the unresponsive partner finally broke contact. The outcome was, regrettably, disappointing. Several weeks ago, this partner unilaterally decided that my client was no longer part of the business. He removed my client from the business bank account, halted all profit distributions, and issued a contract offering to buy back equity, but only if my client agreed not to sue. The threats were vague but implied litigation. Now, on to the current situation. My client has retained a litigation attorney of the top and most expensive in town. While we are following his legal advice, my client had an idea and ran it by me first, potentially to reduce billable hours spent on hypotheticals. The assumption is that unless the partner formally buys my client out, they remain entitled to their pro rata share of any distributions issued to other members, without any obligation to continue service to the business. Buyout discussions are currently deadlocked, so the question is, can my client simply wait for a distribution to be made and then sue in small claims court to recover their 20% share? This seems like it could be a cost-effective, piecemeal remedy and perhaps one that incentivizes honest buyout discussions. Each distribution would likely fall under the 10-0 small claims cap. So, is this a viable legal strategy? And if so, who should be named as defendants? The company? The 2 other partners? All of them? Also, now that my client has been removed from the bank account, how would they even know a distribution has been made? They understand they are entitled to inspect company records, but what specifically should they request in this case, and how trustworthy are the accounting records likely to be? Update. My client is working with not 1, but 2 attorneys and follows their counsel closely. They come to forums like these because, admittedly, they're a bit neurotic, and being neurotic with your attorney can get expensive fast. Today, we have both a brief update and another legal question. First, the update. For the past 8 months, my client's litigation counsel has been pressing the company's attorney for access to financial records that my client, as a member, is entitled to under Oregon law. Despite repeated promises to deliver those documents, in some cases outright stonewalling, nothing materialized. So in November, we filed a lawsuit against the business in standard civil court seeking injunctive relief, namely, access to company records and attorney fees, which are also recoverable under state statute. The registered agent for the LLC, my client's majority partner, actively avoided service until January. Once served, no formal response was filed until the day after we noticed our intent to take default. The response came from a different attorney at the same firm, who denied every allegation and claimed my client no longer held any ownership interest in the business. A third lawyer from the same firm then reached out, asking, "Let's talk. What do you want?" We replied that my client wanted a fair buyout. They responded, "Okay, how much?" We answered, "Send the damn records so we can find out." They said, "Sure, give us 2 days. We have them, but our admin needs to label them." That was 2 weeks ago. We've since resumed pursuing the records and again, we're being stonewalled. Given the partner's prior conduct and the way this firm has handled negotiations so far, I am advising my client that the opposing side likely has no real intent to settle and is simply trying to delay. To top it off, this morning we uncovered that the business has altered certain official documents in ways that are very much not in my client's favor. Both of my client's lawyers are livid, and we're scheduled to discuss a potential shift to a contingency agreement next week. Which brings us to the current question: what factors should my client consider before accepting a contingency agreement? They understand the basics: potential case value, cost of litigation, and the contingency fee structure, but beyond that, they're not sure what other angles they should evaluate. On one hand, contingency agreements can feel like a blessing because they reduce the uncertainty of legal costs. That's understandably appealing, though my client is not facing financial hardship at the moment and has been pleased with how efficiently their attorneys have worked. Continuing to fund the litigation independently remains feasible for now, and it means retaining full claim to any recovery. So they're asking, what else should they be thinking about? Update. Hello again, our legal advice. My client appreciates the community's ongoing support and wanted to provide an update. They've posted multiple times as the situation developed, but here's a recap of the most relevant facts. My client was a minority shareholder in a small Oregon business where they also worked. When they decided to step away from operational involvement, the majority owner reacted by firing them, effectively freezing them out of the business. He cut off access to bank accounts, halted all distributions, and threatened legal action to recover all the money my client ever received from the business. Understandably, this was both frightening and infuriating, prompting my client to retain counsel. After exhausting peaceful resolution efforts, we filed a document inspection suit in November, asking the court to compel the majority partner to provide agreements and financial records so we could determine what exactly he was doing and the full extent of any potential wrongdoing. This step was significant. My co-counsel, a lawyer with over 30 years of experience, said it was the first time he had ever needed to file such a suit in Oregon because under state law, inspection suits carry mandatory attorney fees. As a result, businesses almost never allow them to reach litigation. Despite having legal representation the entire time, the majority partner refused to accept service for 2 months. When he was finally served in January, he delayed further, ignoring deadlines until we filed a notice of intent to take default. Only then did his lawyer respond denying all claims and countersuing for attorney fees, which they are not eligible to recover in this context. Then, in March, during routine background work, my co-counsel's assistant discovered that the business had filed amended documents with the stated documents that had been altered to completely remove my client as a member or owner. In short, my client's former partner was attempting to erase them from the business's legal history. We responded by proceeding with the original inspection suit, while also filing a new claim against the partner personally for breach of fiduciary duty. This allowed us to use the inspection suit to recover legal fees and conduct extensive discovery, which would then carry over to the personal case. At this stage, I offered to represent my client on contingency. Given how quickly the litigation was escalating, and the fact that I was already deeply committed to the matter, it made sense for both of us. I also credited prior fees paid toward future expenses, helping ease the financial burden. This felt like a turning point for my client. Securing contingency counsel in a contract dispute, especially one involving closely held business is fairly rare. It affirmed both the strength of the case and my belief in its merit. Privately, I was also furious at how their partner had conducted himself. I'm at the stage in my career where I choose my cases carefully, and this was one I was determined to pursue all the way. Fast forward a few months, and we finally deposed my client's former partner. I wasn't surprised when it pushed me further. Reading the transcript afterward was both absurd and deeply frustrating. I told my client it ranked as the third most frustrating deposition I've ever conducted. Not the top honor, but close. Following that deposition, the opposing counsel, his third attorney, so far reached out to us with a settlement offer. It was insultingly low. We declined, but indicated our willingness to mediate. Ironically, mediation was my client's original idea before any of this turned litigious. They had suggested it in good faith early on, but the partner backed out last minute and then disappeared. Now, months later, they suddenly agreed. We spent a full day in mediation. When negotiations finally broke down, we accepted a mediated settlement. After contingency fees were deducted, the final amount wasn't far off what my client initially believed they were owed. Emotionally, it brought closure to an exhausting 2-year ordeal. Throughout the case, my clients often second-guessed themselves and carried guilt over suing someone they once cared about. But the truth is, their former partner forced the issue. My client stood up for themselves and won't spend the rest of their life asking, "Why did I let him get away with that?" This former partner had a strong cult of personality. He's charming and persuasive, used to bending people to his will. I suspect no one had ever seriously challenged him until now, and it left him flat-footed. It was an emotionally confusing journey. Nothing the partner did made logical sense, until he was squarely backed into a corner and staring down trial. At every turn we wondered, is this a trap? Is there some genius tactic we're missing? But there wasn't. He had no strategy beyond ignoring the issue until he no longer could. Financially, my client walked away with a healthy bank account, but as they've shared with me, the money feels hollow. They lost a friend and a business partner. Then again, it was clear the relationship was already gone, so at least they emerged with compensation. My client and I were both grateful we found each other for this fight. I suspect that without a contingency agreement, they might not have been able to carry it through to trial. And though I was satisfied with the outcome, part of me does wish we'd gone to court, because sometimes winning is about more than just the money. Story 2. NSW, Australia. Last month, a friend began to cross a flooded river in his car with me in it. I jumped out because I'd been caught on a flooded causeway before. I now have a letter from his lawyer asking for damages because the car was washed off the causeway and written off. Long-time legal advice reader here. My client came to me after receiving a letter demanding damages tied to an incident that took place in New South Wales, Australia. In early November, my client accompanied a friend, let's call him Aaron, to pick up car parts purchased online. They used a series of back roads to access the property. Although it had been raining intermittently, the downpour intensified significantly while they were loading the vehicle. On their return, they approached a causeway they had crossed an hour earlier, only to find it now submerged under what appeared to be roughly half a meter of water. My client, who had been navigating, suggested they turn back and take a longer detour that included a bridge crossing the same river about 10 kilometers away. Despite the inconvenience, my client strongly opposed attempting to cross. The reasoning was sound. 2 decades earlier, my client had experienced a near-catastrophic incident on a similar flooded causeway, losing control of their own vehicle. Though that earlier car was ultimately recovered, the event left lasting psychological trauma. Given the significantly deeper water that day, my client exited the vehicle immediately well before it entered the flooded section, and did not compromise its structural integrity by doing so. Aaron, however, chose to proceed. He failed to reach the midpoint before the floodwaters swept his car off the causeway. The vehicle rolled over, landing upright 50 meters downstream. Aaron was fortunate to survive. My client, upon witnessing the incident, ran to assist and helped extract him from the wreckage. Instead of gratitude, Aaron immediately blamed my client, alleging that had they remained in the vehicle, the added weight would have provided sufficient traction to make the crossing. He cited my client's body weight over 130 gas, a factor The assertion ignored the fact that the car, a 1,650 Grand Commodore wagon, already loaded with several hundred kilograms of parts, was well beyond the point where passenger weight would meaningfully alter its hydrodynamic profile. Following the accident, they waited out the weather. The floodwaters subsided within an hour, allowing them to walk across the causeway. My client has had no further contact with Aaron since, noting that Aaron has actively avoided places where they usually cross paths. Then, on a Friday, my client received a demand letter on the letterhead of a legitimate local law firm. The letter sought 50 in damage, ostensibly the value of the vehicle and personal losses, based on the claim that my client made the car unsafe by exiting before the water crossing. For context, the vehicle in question was a 1997 Commodore, estimated to be worth around $1,500 in optimal condition. From my perspective, Aaron's claim is frivolous and legally indefensible. My client is under no obligation to remain in a moving vehicle if they perceive a safety risk, particularly during extreme weather events where crossing submerged roads is explicitly advised against by emergency services. At this stage, my client has asked whether they should contact the law firm directly to confirm the letter's legitimacy or retain legal counsel to issue a formal response or both. They suspect the letter may have been drafted by Aaron himself and simply issued under legitimate letterhead without actual attorney oversight. Excellent comments. Commenter. One commenter, formerly a practicing lawyer in New South Wales, offered helpful general guidance for my client. While no longer licensed, their input helped contextualize the situation. They advised reviewing the letter of demand for compliance with statutory requirements, specifically whether it includes a due date and allows sufficient time for a response. Failure to meet these criteria could invalidate the letter as a formal demand under NSW law. They strongly recommended that my client refrain from contacting Aaron or discussing the situation with anyone connected to him. No direct communication, written or verbal, should occur. The Reddit post itself, they cautioned, might also be used in cross-examination and could undermine my client's credibility should this escalate into litigation. Their ultimate advice: retain legal counsel immediately. Let a lawyer draft the response to the demand letter and provide legal strategy going forward. OOP, my client. My client confirmed that the letter lacked any specific demand date or response timeline. It simply accused them of causing 50 in damages due to their actions, implying liability without outlining legal consequences, court filings, or payment logistics. This led my client to believe the letter was likely not a legitimate demand under NSW law. They acknowledged the advice to avoid contact with Aaron and decided against forwarding the Reddit thread, as originally considered. However, my client wondered whether they could independently verify the letter's legitimacy, perhaps by checking the law firm's contact details and sending an email with a copy of the letter requesting confirmation. They were unsure whether even that step should be done through a lawyer, recognizing that it might exceed what non-legal forums could advise. They concluded by noting they would likely hire counsel within the week. Commenter. Responding further, the original legal commenter agreed the letter, lacking statutory demand elements, was poorly constructed. They also reiterated not to take the accusatory tone of the letter personally. From Aaron's unfounded legal perspective, he believes my client caused the loss and is attempting to initiate recovery. They explained how to independently verify legitimacy without cost. Use the return address on the letter to identify the firm. Cross-reference contact details with the NSW Law Society's public register. Send a neutral inquiry. I refer to the enclosed letter dated X, a copy of which is attached. Please confirm in writing whether you are currently acting on behalf of Aaron's full name. They emphasized not to take phone calls or engage in informal conversation. No substantive issues should be discussed, just confirmation of authorship. Ideally, even this outreach should be done through legal representation. Update. My client visited a local attorney recommended by their parents. Upon reviewing the letter, the attorney immediately expressed concern and agreed to take over communication. She contacted the listed law firm and later confirmed that they had no record of representing Aaron. My client's suspicions were correct, the letter was fraudulent. Shortly after, Aaron admitted directly to my client that he had fabricated the legal notice. He then requested that my client retract the complaint he assumed had been made to the law firm. My client, having made no such report themselves, responded with colorful language, essentially telling Aaron to go pound sand, though their wording may have involved a more graphic suggestion. We appreciated the earlier community advice, particularly the user who, while no longer practicing, gave spot-on suggestions that helped my client navigate the situation and decide to hire a legal professional. Story 3. Please hear me out. My client went on a date arranged through a dating site, Plenty of Fish. The individual they met had presented himself as a 30-year-old man during their conversations. However, when my client arrived at the restaurant, it was immediately apparent that the man was significantly older. Upon confronting him, he claimed the discrepancy stemmed from outdated photos and a typo, stating he was actually 45 years old, even though his profile had clearly stated 30. My client, understandably uncomfortable with the misrepresentation, politely declined to continue the date, expressing that they were not interested in someone nearly 20 years older. The man became agitated, raising his voice and insisting that my client was obligated to stay because he had already ordered a meal and wine on their behalf. At that point, my client informed the bartender of the situation. The restaurant manager then escorted them to their vehicle for safety, while the bartender remained with the individual to ensure no further confrontation occurred. My client believed the situation was behind them. However, a few months later, they were served with legal papers at their workplace stating that they were being sued. The man had retained a real attorney and was seeking reimbursement for the dinner and travel expenses. His argument? That my client's rejection constituted unlawful age discrimination. The plaintiff's legal team had apparently built the case around claims that rejecting someone based on age, especially after a dinner had been ordered, was grounds for civil damages. He had managed to track down my client's employer after learning their last name via social media, despite its rarity. Since the incident, my client has secured all social media profiles and locked down any identifiable online information. They are aware that the suit is highly unlikely to succeed, but are unsure whether they need legal counsel or if self-representation is a viable option, especially considering financial pressures like student loans. They're asking, is it possible to appear in court pro se and effectively represent oneself against a meritless claim like this without being overwhelmed by the opposing attorney? Any and all insights are welcome. A comment with some legalese by you, Tata Bizkit. One legal-minded commenter offered an in-depth explanation of why the lawsuit is unlikely to hold up. The comment focused on the legal principle of detrimental reliance, essentially, I spent money based on a promise you broke, and now I want compensation. They clarified that detrimental reliance is a type of equitable claim, which is not based on standard contract law but rather on fairness. In theory, someone might try to argue that they relied on another's promise to their detriment, but the bar for such claims is high. They noted that in ordinary dating scenarios, no showing or leaving early doesn't give rise to damages. Even in extreme cases, like pre-disclosed substantial travel expenses, damages would be limited to things the other person was made aware of in advance. Ordering food and wine without someone's knowledge or consent doesn't qualify regardless of how expensive the items were. Furthermore, dating inherently includes the right to withdraw at any time. If someone shows up and finds the other person isn't what they expected physically, behaviorally, or otherwise, they're under no obligation to stay. Even if this situation did somehow pass the basic legal hurdles, bad faith on the part of the plaintiff such as lying about one's age would torpedo the case under the maxim, to get equity, one must do equity. They further explained that legal concepts like quasi-contract or promissory estoppel are meant to protect people when a promise causes real-world harm or loss. But even these doctrines require that the promise was clear, the reliance reasonable, and the damage predictable. None of those elements were present in this case. For instance, a more legitimate scenario would be if an employer promised lifetime retirement pay, and someone retired in reliance only to have that promise revoked. In that case, the person could seek compensation for the loss of their job, even if the promise wasn't legally binding in a strict contractual sense. UP date, Nov 25, 2018. First, I want to thank everyone on behalf of my client for the overwhelming support and helpful advice. The original post even made best of legal advice, and it's meant a lot to them during a very stressful time. Unfortunately, this update contains both good and bad news. The good: my client found an attorney willing to assist. At their initial meeting, my client explained the situation in detail and offered to make payments or even sell their car if necessary to cover legal fees. Whether moved by the holidays or simply by compassion, the attorney agreed to take the case without charging up front. Instead, they requested a donation or volunteer work at a local charity in lieu of payment. Their initial approach was to issue a strongly worded letter to the plaintiff's attorney, pending further developments. The bad: law enforcement is now involved. While I won't go into unnecessary detail out of caution, I can confirm my client is physically unharmed. That's the most important thing. What I can share, because it's already been reported, is this. After my client changed their phone number and increased personal security, the individual showed up at their apartment complex. When turned away by building security, he brandished a weapon. He has since been connected to an unrelated criminal investigation in the same area. Again, the priority is my client's safety, and they are now working closely with authorities. They've also started therapy to address ongoing anxiety and panic attacks caused by the incident. As an additional note for those curious, the damages originally sought in the lawsuit totaled over $6,500. The plaintiff alleged $250 for dinner at a chain restaurant, despite the actual prices being far lower, $150 for fuel used in a gas guzzler, and most absurdly expenses for a trip to South Africa he claimed to have begun planning after learning my client wanted to visit there someday. My client used humor throughout the process as a coping mechanism, but behind that is real trauma. They are incredibly grateful to be safe and moving toward healing, and we both thank this community again for being such a source of guidance and support. Story 4. HR won't do anything about a co-worker who's angry about my client's weight loss. February 8, 2023. My client returned to work after a month-long emergency medical leave. The short version: after a decade of being dismissed by healthcare providers, a new doctor finally ordered an emergency MRI during a routine visit. That scan revealed an 18-pound benign tumor pressing on my client's organs. They were rushed into surgery within 24 hours and, thankfully, survived what had been a near-lethal situation. Though there may be long-term health consequences, for now, my client is doing well. One obvious outward change: they went from a size 20 to a size 8. This drastic transformation wasn't anticipated, but the medical team has confirmed they are healthy. Emotionally, my client is still working through things. They expected some questions at work due to the noticeable weight loss, and they prepared a simple explanation: emergency surgery, but I'm fine now, which sufficed for most people. Except for one co-worker, Aubrey. My client barely interacted with Aubrey before this. Aubrey styles herself as a health coach and is known around the office for dispensing unsolicited, and frequently incorrect, dietary and fitness advice. On my client's first day back, Aubrey approached and said, "I wish you had come to me to lose the weight instead of resorting to such drastic measures. You're going to gain it all back, you know. I'll be waiting." Aubrey continued her harassment throughout the following week. She suggested my client had opted to get butchered rather than putting in the hard work, and later showed up outside my client's office in gym clothes, offering to accompany them to a workout session. At that point, my client hadn't even been cleared to carry laundry or lift their child, let alone exercise. When they declined, Aubrey responded that my client was lazy and would inevitably regain the weight. The harassment escalated when Aubrey unprompted spoke about my client in a meeting they were not present for, implying that anyone who couldn't commit to weight loss surely couldn't be trusted with professional responsibilities either. That triggered a red flag mediation. In this company, such mediations can negatively affect bonus eligibility. Despite Aubrey being the aggressor, both employees were subjected to the same process. At the mediation, Aubrey claimed she had been triggered by my client's changed appearance and insisted that my client should have warned her ahead of time. My client barely had time to notify family before surgery, warning a casual co-worker wasn't even a consideration. While my client felt some empathy for someone clearly struggling, that didn't justify Aubrey's behavior. HR responded by suggesting, though, not requiring that my client disclose their medical history to clear the air. My client rightly declined. They stated firmly that no one is entitled to personal medical information, and another person's discomfort doesn't override their privacy rights. HR's response was, "Well, then we can't stop her from bullying you." After Thanksgiving, my client's doctor submitted ADA accommodation paperwork to allow remote work both due to post-surgical complications and to avoid further contact with Aubrey. The company is notoriously resistant to remote work, so this wasn't received favorably. Aubrey, meanwhile, continued her harassment by emailing my client unsolicited workout routines and diet plans. Each time my client forwarded these to HR, their only response was, "Noted. Do you know when you're coming back to the office?" At that point, my client began seriously considering whether it was time to escalate the situation to corporate leadership or retain an employment attorney. They were physically and emotionally drained. The weight loss obsession from Aubrey echoed the very medical gaslighting that had endangered my client's life in the first place. They had worked at this company for 5 years and expected more from HRAT, the very least, neutrality. Instead, they received passive responses and appeared to be the only one bearing consequences for Aubrey's inappropriate behavior. UP Deet, April 17, 2023. Hold on to your banana pants, things got even more surreal. First, to address the common question. Where was management in all this? My client's direct manager, George, was approaching retirement and mentoring his successor when all this began. Both George and his replacement were baffled by the situation. Together, they met with Aubrey's supervisor and agreed that Aubrey needed to be reined in. My client had been documenting every incident from the start, and all 3 managers were aligned in their support. None of them initiated the red flag mediation. That was HR's idea. Despite Aubrey's disruptive behavior, including a meeting where she was reportedly asked to leave by her own boss and chastised by co-workers, HR decided that both parties should face mediation, which carries potential bonus penalties. George and the other managers formally objected to HR's framing, but their concerns were ignored. George then took the issue to the next level and spoke with the HR generalist's manager, who said, inexplicably, that my client's absence may have caused stress for Aubrey, despite the fact that Aubrey wasn't even qualified to handle my client's responsibilities. Throughout this, my client's department leadership remained supportive. Even their professional mentor provided comfort until she too resigned for unrelated reasons. When my client's doctor extended their ADA accommodation a second time, HR replied that their attendance was a concern. My client escalated the issue to the HR director, asking how medically documented remote work could be framed as an attendance issue. The director doubled down, saying medical documentation doesn't hold much weight within the company. That's when I got involved. As counsel, I advised my client to contact the company's highest HR executive. With their manager's blessing and my support, my client reached out to the Chief Human Resources Officer, leaping over 5 layers of HR leadership. The CHRO had no idea any of this was happening. My client relayed the entire history, including Aubrey's bullying, the red flag mediation, and the HR director's comments minimizing ADA and FMLA protections. The CHRO was appalled. She immediately scheduled a meeting with both of us. At the meeting, the CHRO was visibly disturbed by what she heard. My client hardly needed me to speak. She presented clear records, emails, and correspondence. The CHRO confirmed that what happened was unacceptable at every level. She immediately offered extended paid medical leave to support my client's recovery, and assured us that Aubrey's emails and fitness plan spam would be dealt with swiftly. Aubrey went quiet after that. Informal channels later revealed that the HR staff involved in the red flag mediation and in downplaying ADA, FMLA protections were let go. Aubrey, surprisingly, was not fired. The TRO believed she had been misled by HR and was acting on poor guidance. While we didn't fully agree with that reasoning, it made sense from a corporate liability standpoint. Aubrey was placed on a strict performance improvement plan. But then things took a turn for the fully unhinged. Aubrey showed up at my client's home. Still on medical leave, my client was at home when Aubrey arrived, flanked by 2 women. As commenters had previously guessed, Aubrey was now deeply involved in what appears to be an MLM, perhaps something even more cult-adjacent. She came bearing workout demonstrations, supplement samples, and a career opportunity, stating she was worried about my client's physical and professional health. Fortunately, my client wasn't the one to answer the door. Their mother-in-law, who had been helping care for them, made it clear that Aubrey was not welcome and shut down the encounter swiftly. We immediately reported the visit to the CHRO and took appropriate legal steps. Shortly afterward, Aubrey left the company. She now works full-time as a wellness coach. With management changes, HR, upheaval, and my client's mentor and supervisor both gone, the company is undergoing a broader restructuring. My client is not sure whether they'll return when medically cleared. Their department may be dissolved or distributed across regions. They've started looking into full-time remote roles, knowing now what kind of culture they want to avoid in the future. To the community, thank you again for every comment, message, and word of encouragement. This saga was far more than just a workplace dispute. It was a test of resilience, and with the right support and legal guidance, my client came through stronger.